Good morning. We are here for oral argument in CV 20-0203, State of Arizona versus Series 5. As is standard, each side will have a maximum of 20 minutes for argument. You are not required to use all of that, but you are welcome to do so. The appellant may reserve some portion of your time for rebuttal, although you are responsible, as usual, for managing your time. Due to the remote nature of this argument, we have a small clock, which I believe you should be able to see in the on your screen, and so you can track your time with that clock. We are recording this argument and will ultimately post that recording to the court's YouTube channel. So for clarity of record, please identify yourself and your client when you begin speaking. We, of course, hope that there are no connection or other technology failures, but should something occur, we have agreed that should one of the judges drop off, which we don't anticipate again happening, we will continue the argument and that judge will review the recording later. If one of the attorneys drops off, we will suspend the argument until that attorney is able to rejoin us. Please keep in mind, we have read all of the briefing. We have reviewed the record. We've discussed this case in conference, and with that, please proceed.
Thank you, Your Honor. Good morning. This is Assistant Attorney General David Jacobs representing the state of Arizona. I plan to reserve 5 minutes for rebuttal. In 1971 and 1972, in State versus Benelli Cattle Company, the Arizona Supreme Court ruled that the land immediately adjacent to the parcel at issue here was state sovereign land belonging to the state of Arizona. The state contends that there is no basis in law or fact to support the Superior Court's reaching the opposite conclusion with respect to the 9 acres of land at issue in this case. The Superior Court cited definitions of accretion and avulsion for Benelli, and in stating its holding, the Superior Court used similar words as Benelli. The court found that the movement of the river was not gradual and imperceptible, but instead was sudden and perceptible, and therefore an avulsion under Benelli. But in applying Benelli, in applying the Benelli definitions, the Superior Court failed to incorporate the usage and meaning of those definitions in this context. This context is a common context in Arizona, which is an alluvial stretch of river with easily erodible banks. In that context, rapid erosion alone does not constitute an avulsion. It is an accretion, in which case the state's sovereign ownership of the bed and banks of the river moves with the ordinary high water mark of the river.
Counsel, I thought that with accretion, it had to be imperceptible, but I imagine that the floods of 1912 and 1914 were anything but imperceptible, and the changes to the river wouldn't be imperceptible either.
That is correct, and that is why the definitions applied in this context of a easily erodible banks of the river, an alluvial stretch of the river, needs to be understood based on the other opinions and the Benelli opinion itself and the way the language is used. For instance, the Superior Court's error is apparent here because other than the Superior Court here, no other case has concluded that an avulsion occurred on the Mojave Reach of the Colorado River where the subject property is located.
Counsel?
Yes.
Would you concede that when the Arizona Supreme Court considered Benelli 1, they did not have, for whatever reason, the floods of 1912 and 1914, they did not consider those as those facts were not introduced?
I guess there are two issues there. One is we don't know exactly what was before the court. We know there was an agreed statement of facts. We also know there were maps and descriptions of the extent of the movement of the river. Perhaps not broken down into what happened between 1912 and 1915, but certainly we knew, certainly the court knew, that between as early as 1903 and as late as 1938, the river's banks moved a mile. So that was a substantial movement of the river. And nonetheless, the court still ruled that you could cite what the Benelli Supreme Court decision wrote, that in the instant case, the changes in the water course were, quote, imperceptible. So a large movement of the river was still considered to be imperceptible by the Arizona Supreme Court when it decided Benelli. In addition, the manner in which
those changes came about is not particularly relevant from your position. Whether it was as a result of 2 floods or not, it doesn't affect the calculus.
Correct, because the history of how this standard has been applied has shown that what the courts are looking for when they're looking for sudden and perceptible changes is in an alluvial, easily erodible stretch of the river, is that they are looking for something more than the banks moving rapidly. They're looking for something more than rapid erosion. What they're looking for is what the court decided in the Arizona Supreme Court decided in the Jacobs case, which is they're looking for a channel jump. They're looking for a circumstance where the river changed course and moved to a new channel, which was separated from the old channel by dry land. That is actually what the courts are looking for in this instance. And
but Benelli doesn't necessarily require that. Benelli doesn't say that.
I think Benelli says that in several ways. First, Benelli says that from the fact that clearly the river's movement was perceptible. I mean, it moved a great bit. So that is one way we know that. Another way we know that is that, you know, the Benelli logic of the internal logic of the Benelli opinion wouldn't make sense applying those words in that way. For one thing, if there is an accretion, the sovereign boundary moves with the bed and banks of the river. That is the whole purpose of the doctrine. But if we're only looking for imperceptible movement, then basically the river's banks haven't moved at all. So in that sense, there's really no movement to track the boundary in that case because it hasn't moved. If we are saying that every time the river's banks move, it is going to be an avulsion, then the court's analysis basically stops there. It would make no sense for them to continue with the analysis.
Well,
and that is,
the banks could move imperceptibly over time, and that I would agree would be an accretion. But if you see it move, and as Benelli says, when it changes to sudden and rapid, the change is said to be an avulsion. So if you have a massive flood, as occurred in 12 and 14 or 15, whatever years it was, and sudden and rapid, and so by the definition, the change is said to be by avulsion.
I will answer that one second. Can I just say that the clock is frozen, and I don't know when it froze.
Oh.
Okay. All right. Thank you. So the nature of sudden and rapid, all the cases that the state has described in its brief, there was, in every one of them, there was example of sudden and rapid movement of the river. The Benelli court itself recognizes that it is common knowledge that the river moved sometimes suddenly and rapidly. It is a violent river. It is a type of river, especially in this stretch of the river, that often move. That is the norm. So for it to move, for the court to establish a doctrine where the normal course of movement of the river is an avulsion is contrary to the nature of the doctrine itself. The court established a presumption that the river moves by accretion, and it requires events so momentous that evidence is available to establish them in order to establish avulsive changes. So the courts established that's a presumption based in logic. The norm is accretion, and the norm in the movements of the river is by rapid, is often rapid erosion, certainly if the river.
But that presumption theoretically can be overcome in any particular case if sufficient evidence is presented that there was a sudden and rapid change. And, I mean, it sounds like our discussion today, your definition of what an avulsion is doesn't have anything to do with sudden and rapid movement. The only definition you accept that you're proposing is that there must be an immediate channel change.
Well,
That's the only thing that qualifies as an avulsion.
that is correct. And the reason is both because that is what all the other cases and all the other studies have established, that is what it means by a sudden and perceptible movement in a stretch of river like this. And I would also point out that otherwise, what is sudden and perceptible? There is no case that really draws a line there, because it is an impossible line to draw. The channel jump analysis is easily discernible. It is clear, and it describes a momentous event. There's no question that a channel jump is a momentous event when the river changes course. In this case, there are no cases that say, for instance, moving 100 feet in a month is sudden and perceptible, but moving 100 feet in 2 months is not. That type of analysis doesn't make any sense. It's not something that the courts are able to apply, and it's certainly not something the courts are able to apply in a way that is predictable for landowners along the river. So the state's argument is that, yes, the words do say sudden and perceptible, but every application of those words applies them in the way the state is arguing. There are all the cases out there and all the studies out there to describe what could only be it's certainly perceptible changes in the river, at times sudden changes in the river. None of these are determined to be an avulsion. The only avulsion that was ever found was the channel jump down north of Yuma, and that was the subject of the Jacobs case before the Arizona Supreme Court.
So if there's a massive flood where before you had one channel, and after the flood you end up with an alluvial fan sort of thing where several channels, that by definition is not an avulsion because it didn't change from one channel to another. It changed from one channel to several channels.
That is correct, because there would be question one where the ordinary high water mark was, and that is something that have to be assessed on the particular facts of the case. But that would continue to be an accretion because the river could continue to move in that manner. There is just would be a stream of movements of rapid erosion in that manner, all of which would be an accretion.
So, counsel, are you saying that would be imperceptible?
It would be imperceptible, as the courts have used that term in this context, and that is a usage that goes all the way back to at least the United States Supreme Court Nebraska versus Iowa opinion in 1892. The state here is not making up language that was not used this way before. In fact, the state is applying what is essentially the unanimous usage of this term throughout, at least throughout the history of Arizona. The Nebraska versus Iowa case, which explained why in an alluvial stretch of river and an easily erodible stretch of river, sudden and perceptible change in itself, rapid erosion in itself, is not sufficient to be deemed an avulsion. That is the norm. That is the standard that every Arizona authority before the Superior Court has applied, and all their holdings are consistent with that definition, with that use of the term.
So when the court says when the change is sudden and rapid, the change is to be an avulsion, that's not what they meant, because that's the English language interpretation of sudden and rapid. So what you're saying is that those terms have technical meanings in this area that should be applied.
Correct. That's what I am saying. That's what the state is saying. There is a technical definition here.
Are there any other Arizona cases that say that those words have that particular technical meaning?
Well, I would say we're discussing this in a manner that is different than it was, but I think if you look at the Gunther and Shirley case, which basically explains this, it's this case in a nutshell. The Gunther and Shirley case was decided by the Court of Appeals just 4 years before it decided Benelli, and in fact, Judge Cameron wrote both opinions. The court examined substantial movement of the river's banks in the area in Yuma where the river moves east-west. The court examined similar peak flood flows to those experienced at the subject property just after statehood. Court described a great deal of movement of the river's banks. For instance, a quote minor addition of 950 feet, which is an area just less than the greatest width of the subject property here. And nonetheless, and the court also cited the gradual and imperceptible definition of accretion. Nonetheless, the court ultimately ruled that the circumstance in that case, similar to the circumstances here, was an accretion. The court distinguished those circumstances from an avulsion, which is, the cutoff as I described in Jacobs. In that case, the river changed its course, leaving dry land between the old and the new channels. The court cited as particularly persuasive the testimony of Pearlie Lewis, who found that in the absence of cutoffs or jumps, and that's a quote from the opinion, the river moved in the normal manner of deposition and accretion. And Pearlie Lewis is one of the experts that the state relies upon regarding the Mojave Reach, the northern section near Bullhead City, near the subject property. So the defendant is asking this court to apply instead of the holding of that opinion, the defendant's asking this court to apply the reasoning of a study that was rejected by that opinion, if not specifically, at least in concept. They refer to the Leonard Halpenny study, which studied the same stretch of river in Yuma. Halpenny, like the defendant and its expert in this case, argued that a channel jump is only one example of an avulsion. Halpenny, like the defendant and its expert in this case, would have found that the river moved by a series of avulsions, but that is not what the court held in Gunther and Shirley. Halpenny's analysis, like that of the defendant and its expert, does not reflect the Arizona law as it's been applied, because neither the Gunther and Shirley court nor any other court has found even one avulsion occurred in those areas, even though they do use the language that you and I are discussing, the sudden and perceptible, gradual and imperceptible language. And if I can reserve the rest for rebuttal, I would like to. Thank you.
Thank you, counsel. Go ahead. I'm sorry, you're on mute. Hold on just a minute. We can't hear you. Jason, are you or Shelby able to unmute Kevin Parker?
I am not unable to unmute him.
Can you hear me now?
There we
Yeah.
go. Yes.
Okay, thank you. May it please the court, Kevin Parker for Appellee Series 5. I think the court's discussion so far has focused on what is the crucial issue and the distinction between the parties' positions. The state's position is that the only thing that qualifies as an avulsion is a channel jump. River suddenly leaves its old bed and jumps to a new bed, leaving undisturbed land in between. According to the state, everything else is an accretion. Our position is there are essentially two columns. The accretion column is slow, gradual, and imperceptible movement, and the avulsion column is sudden, rapid, and perceptible movement. In our position, we would put a channel jump in the avulsion column, not as the definition, but as an example of an avulsion. We have 5 Arizona cases that have been debated in the briefs, and several of them so far in this discussion. Jacobs, Gunther and Shirley, Benelli Court of Appeals, Benelli 1, the first Supreme Court, and Benelli 2. If the state's position were correct, how would we expect the court in these 5 cases to frame the issue, and versus how did it actually frame the issue? I submit that if the state's position were correct, all of these cases would explain in plain terms, the court would say, to have an avulsion in Arizona, we need a channel jump. Everything else is an accretion. The court would say that It is the burden on the party claiming avulsion to prove that a channel jump occurred. If the party cannot prove channel jump, we would find accretion. But none of the 5 cases say that or anything remotely close to that. Indeed, if the state's position were correct, why do the courts even talk about gradual, slow, and imperceptible versus sudden and perceptible as the categories for the parties to present facts upon? What would be the point of identifying those concepts? They would essentially be irrelevant and meaningless. The columns per the state would be, was there a channel jump or was there not a channel jump? I'd like to go through briefly the 5 cases, the 5 Arizona cases. Jacobs is a criminal case. Page 339, the court says accretion is gradual and imperceptible. Also at page 339, when the stream changes course suddenly or uses the disjunctive or in such a manner as not to destroy the identity between the old and the new, the change is termed as an avulsion. Page 339 of that case, the court talks about within a matter of minutes, the river cut a channel. Why does the court even talk about how long it took? If an avulsion is only a channel jump, what does it matter? So the whole discussion of Jacobs is contrary to the state's position here. Gunther and Shirley, the next one, it directly quotes from Jacobs. It likewise uses the disjunctive language for avulsion, sudden or the channel jump. Accretion is defined as gradual and perceptible. Counsel mentioned that the court quotes some testimony from one of the witnesses, Mr. Lewis. Actually, if you look at page 82 of that opinion, the question to the expert witness was, were there any sudden or violent cutoffs or other sudden changes? That's the question to the expert. Next case is the Benelli Court of Appeals case. Page 417, we're not in a position to determine from the record whether the change was accretive or avulsive, nor do we believe the record was sufficient to enable the court to do so. Also page 417, accretion, here's the terms used to describe accretion: natural, gradual, river moves slowly, slow, imperceptible process. The court says that given there was no evidence, this is page 418, that is an indication that the movement was slow and imperceptible, and therefore, key term, and therefore accretive rather than avulsive. If the court were subscribing to the state's theory that only a channel jump is avulsion, why wouldn't the question be posed? There was no evidence of channel jump and therefore accretive rather than avulsive. Next case, Benelli 1, the Arizona Supreme Court. No mention of channel jump at all. The issue is framed, page 467, accretion, gradual, imperceptible process, sometimes so slow as to be imperceptible during the lifetime of a person. Avulsion, sudden and rapid. As Judge Howe noted, page 467, the example used by the Supreme Court of an avulsion is sometimes the river moves so rapidly by floods that the river's banks visibly disintegrate. That is a discussion of a widening of a river, not a channel jump. The court doesn't even talk about channel jump. The court certainly does not say there is no evidence of channel jump presented, therefore we find accretion. That is what the court would be, in my view, expected to say if the court was subscribed to the state's position. The whole factual context of the Benelli case is a widening of the river, not a channel jump. According to the state, yes.
Counsel, even if we were to agree that that's the definition of avulsion as far as our courts go, do you agree that as far as the federal government goes and other jurisdictions, they go by the more narrow definition of avulsion, which would only be a channel jump or some kind of cutoff.
Yes, Your Honor. I do agree that there is, and perhaps we can call it the federal rule or the majority rule. But as we explained in our brief, the Bureau of Land Management manual cautions surveyors, make sure you know what state you're in before you jump to conclusions. Some states require a channel jump. Some states include rapid widening, rapid erosion due to a flood as an avulsion. So then we just need to look to see what the state of Arizona is. And based on the 5 Arizona cases, we're not a channel jump state. In fact, the Benelli Court, if we were a channel jump state, there was certainly a sufficient body of law developed to that point where the Benelli Supreme Court could have said, if this was the law, we, Arizona, subscribe to the channel jump theory. The court did not say that. The court, in my view, said something that is close to the exact opposite. It said sudden and rapid. It said, as an example, a river that erodes rapidly due to a flood, that's an avulsion under Arizona law. Sometimes a river moves so rapidly by flood that the banks disintegrate. Banks disintegrate is not a channel jump. And the court said that's an avulsion.
Counsel, could I
yes.
Just briefly interrupt? In terms of the definition that we're applying here, that's kind of the area we're playing in for the moment. The question of what definition applies, what the definition of avulsion is in Arizona, is that a question of law or a mixed question of law and fact? A question of fact? How do we view that in terms of our standard of review here?
I think that is a question of law. What is the standard? So, and that is clearly the standard applied by the trial court, which was also the finder of fact. And so, to a more pointed answer, I think the trial court is allowed wide latitude in terms of the finding of fact that it met the standard, the sudden and rapid standard, but the sudden and rapid standard is a matter of law that this court would review de novo.
Okay.
And I guess just to wrap up that point, that I don't think the state has or can have any explanation of why none of these 5 cases say, just in plain English, we're a channel jump state. Unless you have evidence of channel jump, end of story. They don't say that. In fact, Benelli says the exact opposite. It explores a widening of the river as an avulsion or an accretion. If the state's view of it were correct, they don't even go there. Unless the court has any questions, I'll move to my next point.
One quick clarification on the sudden and perceptible. Is there any guidance somewhere on a time frame, or is it more the perceptible versus imperceptible? The over the lifetime you can't really tell versus rapidly you can tell? Or are you aware of some authority on a particular time frame that we're looking at for sudden?
I am not, Your Honor, but I would point out that the Benelli court does not say it must be imperceptible over the lifetime. It says sometimes it is imperceptible over the lifetime. It uses that as an example, not as a definition. So as counsel for the state noted, this is an alluvial stretch of the river where there's high water every year and pieces of sand are peeled off at high water, probably on a daily basis. That is fundamentally different than the 2 most massive floods essentially ever recorded in Arizona history. The facts are undisputed that, I think indisputable, that before these floods, our property was to the east of the river in dry land. After the floods, the river has consumed the property, and that is established by the 1915 GLO survey. And the surveyor's notes, I think it's trial exhibit 38, which we've referred to in the brief, says the prior survey points have been obliterated by rapid erosion of the banks. So I hope I answered your question, Your Honor.
Thank you.
The next point I was going to get to, but I think I've already covered it briefly, is that I think we have clear evidence of the mechanism of the movement of the river. That we have the surveyor notes I've mentioned, the two most massive floods. Just one is 4 months after statehood. These are unprecedented. There's houses falling into the river. There's also some discussion of the burden of proof that we might have. I think the proper way to analyze the before and after is when the causal agent is a massive flood, it has to be a before and after. There's no possible way for an individual to identify moment by moment the encroachment. That, not to overstate it, that would put their lives in danger. We have a massive floods here. There's no one who could be out there identifying the minute by minute movement and then essentially run for their lives. That can't be the standard. We have a very short window, 20 days for the 1912 flood, 23 days for the 1914 flood. We believe in these circumstances, it's simply a before and after burden for us and identify the most likely causal agent. With respect to our claim for attorney's fees, we think we've briefed that, but obviously if the court has any questions, I'd be happy to answer. And then a brief moment on our cross appeal. First, the cross appeal is a backup argument. We think we win on the primary argument and the court need not even reach it. But to the extent the court does, the point we're trying to make is the equal footing and public trust doctrines exist to enable states to obtain ownership and control of navigable waterways. So in our particular instance, we don't believe the equal footing plus public trust doctrines enable the state to take ownership of property that, number one, was not within the river at statehood. Remember, the state gets the river at statehood under the equal footing doctrine. Here, the property was not in the river at statehood. It's not in the river now. The state does not need and cannot make a plausible argument that it does need this property for navigation purposes under the public trust doctrine. Thank you.
Thank you, counsel. Mr. Jacobs, we'll get our timer back up here. We have about 4 minutes. Hold on, you're on mute. I think you need to unmute. There we go.
Is that better? I'm sorry.
That's right.
So, thank you, Your Honor. So again, the defendant here has cited all the definitions, but they do not cite at all how these definitions have been applied. They do not cite to any case that has found an avulsion under Arizona law or along the Arizona boundary of the Colorado River, despite the fact that this flooding didn't only occur at Bullhead City near their subject property. It occurred all up and down the river. It has been recognized in other opinions. It's been recognized in every expert and technical analysis of the river. None of these other opinions found an avulsion. None of these expert opinions found an avulsion. So again, it's all back to the context and how this language has been used. And
Counsel,
the holdings.
Can you explain to us why you believe that none of the Arizona cases say that channel jump is a required element of avulsion?
I would say that why they don't use those words, because that is the way the words have been used. And the Nebraska-Iowa case explains why. The channel jump is just in an alluvial stretch. That is what they are looking for when they are looking for sudden and perceptible change. Yes, it would be clearer if they had used those words, but the ultimate measure is how the case is held, and the cases all held accretion, except for the Jacobs case where there was a channel jump. And I would argue that the evidence in all those cases is of rapid erosion and is sudden and perceptible changes. They're talking about miles, hundreds of feet of change in the river over short periods of time, just as we are talking about here.
Okay, Council, so when you're dealing with this stretch of the river, which is, or was at least at the time, alluvial, then you can never ever have an avulsion because it geographically cannot occur.
It can occur if there's a stretch, if it takes a piece of dry, if it goes around a piece of dry land in the river. And I believe there are pieces even in alluvial stretches where, like in Yuma, the river still managed to cut through dry land and create, in that case, what is basically an island of dry land between a new channel. That is not impossible. That is just not what happens within the alluvial bottom of the river. It is only where it goes around it. So it is possible, but it did not happen, except in that one example. I would also point out that under the defendant's analysis, the point of the accretion doctrine is to allow the boundary to move, the sovereign boundary to move back and forth with the river for public trust purposes. Under the defendant's analysis, the defendant would have still owned, or its predecessor would have still owned, land that was under the rushing banks of the river. The analysis applied there would not have allowed the banks to move and to serve the public trust purposes. The banks of the river would have essentially frozen in more or less statehood, and the river would be flowing over the private property. There's no way that is supporting the public trust purposes. I guess I would close by saying, we speak about the federal rule. Those are the cases that the Arizona cases rely on. They do not rely on any of the other cases that talk about not a channel jump not being the only avulsion. This is the line of cases that the Arizona courts have relied upon and consistently applied, and that is what the state argues the court should do here. Thank you.
Thank you for your arguments, counsel. We will take the matter under advisement and issue our written decision in due course. And now the court is adjourned.
Thank you.
Thank you.